State, would you please set a record for James Broadway?
Yes, Your Honor. Thank you. This is State of Indiana versus James Broadway. There are two cause numbers, 64D01-2602F61333 and 64D01-2602F61636. The defendant is present in court in person by video conferencing without counsel. State of Indiana by Gary Gurman.
Morning, Mr. Broadway. Can you hear me okay? So first, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you could not be forced to make any statement or testify against yourself at any hearing or trial held in this matter. You understand those rights as I've just gone through them?
Sure.
Okay, and you've been charged here in F61333 with one count. This cause states that on or about February 4th, 2026 in Porter County, you did knowingly or intentionally, it's actually on February 5th, 2026 in Porter County, that you did knowingly or intentionally exert unauthorized control over a Laura Geller Compact Foundation belonging to a Jennifer Badola by taking the package from her porch and with the intent to deprive her of any part of the property's value or use, and that upon a criminal records check, law enforcement determined that you have a prior unrelated conviction for theft or conversion from 2018 in Porter County. You understand the allegation?
Yes, I returned that package to.
Sir, do you understand what they allege you did?
Yes, and I returned it to the police officer, and he said he was not going to charge me with anything.
What's important for me to know is that you understand what they allege.
Yes.
Okay. And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, I want to go pro se.
Okay, let me get into the next part first.
But I just
First, I'm going to enter a preliminary plea of not guilty for you on count 1. And then the state filed on February 25th a habitual offender enhancement. Have you received a copy of that?
I haven't received nothing. Can I say something?
Go ahead.
This case that you're talking about is a summons for March 20th. We're not even talking about why I'm here when I got transferred. That's what I don't understand. That's why I fired off at you.
Yeah, I understand, Mr. Broadway. Like I explained the first time we met, the summons went out, but because you were already in jail, they wanted to make things convenient. So they just wanted me to do the initial hearing while you were already in custody, which was fine with me. So the February, what was it, 20th or whatever date the summons date was, that was vacated. March 20th. So you don't have to be here on March 20th. That date was vacated.
That means your speedy trial is something that I'm still talking about why I'm here. From Speedway and the possession charge was Clymer transferred me to you for that charge. And none of that is being discussed right now. I have 3 different cases going on. I got a Toadies case with false informing, and we got pulled. We didn't even get pulled over. We ran out of gas, and they said they were going to help us. And then now I came here, got re-OR'd, I'm say. So I just want to go home.
Ladies and gentlemen, today's courtroom roundup features two defendants who seem determined to make their own situations dramatically worse. Our first stop takes us back to a familiar face, a man who recently managed to earn himself 6 months in jail, not because of the original charges against him, but because he couldn't stop arguing with and insulting the judge. Now he's back in court facing allegations connected to a stolen package. And if you thought his last appearance was chaotic, you're about to see why judges spend so much time reminding defendants to stop talking. What's fascinating about this case isn't just the allegation itself. It's the disconnect between what the court is trying to explain and what the defendant wants to talk about. The judge is attempting to conduct a straightforward hearing, explain the charges, and move the case along. Meanwhile, the defendant seems focused on proving his innocence right then and there, despite repeated warnings that this is not the time or place to present a defense. It's a courtroom mistake we see over and over again, people believing that if they just keep talking, eventually everyone will see things from their perspective, but that's only part of the story. As the hearing unfolds, we're going to hear discussions about prior convictions, a habitual offender enhancement that could dramatically increase potential penalties, and a debate over whether the defendant should represent himself. Pay close attention to how the judge handles the situation, because he's actually giving advice that could help the defendant, even while delivering news the defendant clearly doesn't want to hear. And if you think that's wild, wait until the second hearing. What begins as allegations of a simple retail theft quickly escalates into claims of violence, a lengthy criminal history, and a defendant who becomes increasingly frustrated when the judge doesn't buy his explanation. The reactions alone are worth watching. So buckle up, because today's hearings are packed with courtroom confusion, questionable decisions, and a master class in how not to help your own case. Hey guys! And welcome to today's video. Today we have two hearings to cover, with one of them being an update to a recent crash out in court. We're going to start with the update where we have a defendant who's being charged with stealing something off of someone else's porch. Now, the last time we saw this guy, he picked up 6 months in jail for yelling and cussing at the wrong judge. So, let's begin.
Broadway. You keep doing a couple things which you need to stop doing. One is that you keep talking about your defenses out loud in front of the prosecutor. You should not do that. You should only talk to about your defenses in front of your attorney. If you're going to represent yourself, you need to do that in some proceeding other than in front of me, because I don't need to hear any defenses until your cases go to trial. You talked about the pending case you have in front of Judge Tody. I'm aware of that. You've got the pending matter in front of Judge Tody. That's why when I'm done with the hearings that I have to complete with you today, I'm going to transfer your case to Judge Tody, because he's got cases. Also, Judge Clymer transferred your case to me. I should never have had that case. It should have gone to Judge Tody, because he's got the pending case, the first pending case, okay?
I understand. Thank you.
You were in jail already on F61636, which was the case that came to me from Judge Clymer, right?
No, I was not.
You were. They arrested you. You were in jail.
Sir, I got a summons by the officer. He told me that he was not going to press charges against me if I returned said package. I did that.
Okay.
Hold up.
I'm talking about one case. You're talking about the other case. But in any event,
you're talking about the March 20th package. I'm in here for Speedway, taking food out of Speedway and having a box that was in my pocket that I found.
That may have been why you were arrested, Mr. Broadway, and I'm not going to disagree with you. That may have been why you were arrested on F61636. You were already in jail for that, and then they saw that you needed to have the initial in F6133, and to make matters easy, they brought you in front of me last Thursday so we could do the initial hearing on that.
But that's not stating why I'm here. This case, why I'm here, is not what you're talking about. But what I'm saying is, the officer said he was not going to press charges if I gave him the said package. I gave it to him. The next day, and my door was even open, and it had a piece of plastic.
Broadway, I need to get through one more part, okay? You keep talking about your defenses. It does not help you.
I'm not. I just want to go home, sir. I keep getting set up to be here, and people get let out of here that has worse charges than me. And
Mr. Broadway, I need to go through the habitual enhancement notice with you as well. You have been filed. The state has filed a habitual offender enhancement notice on February 24th, 2026. I would like to go through it with you. It says that on or about October 7th, 2024, here in Porter County, you were convicted of a felony in 64D02 2406 F6 6181, maintaining a common nuisance, which occurred on June 5th, 2024, and that based on that conviction, you were sentenced on October 7th, 2024 to 360 days in the Porter County Jail, which was suspended. They also say that on June 25th, 2018, in Porter Superior Court 6, you were convicted of auto theft in 64D06 1801 F6 603, which was committed on January 18th, 2018, and that based upon the conviction, you were sentenced on June 25th, 2018 to 365 days in the Porter County Jail. They also say that on January the 6th, 2012, in Porter County, you were convicted of a felony in case 64D01 1108 FD 7679, intimidation, a Class D felony committed on August 12th, 2011, and that based upon that conviction, were sentenced on January the 6th, 2012 to time served in the Porter County Jail. They also say that on December the 1st, 2003, in Porter County, you were convicted of a felony in cause 64D01 0010 DF 8173, possession of marijuana, a Class D felony, which occurred on 26th of September 2000, and that based on that conviction, you were sentenced on December 1st, 2003 to time served in the Porter County Jail. Do you understand what they allege are your prior convictions related to the habitual offender enhancement notice? Do you understand what they allege?
No, I don't. That's not my charges. That's not me. My name is Jamie Clifford Broadway. Not James Clifford Broadway. Jamie Clifford Broadway.
Away, we're seeing one of the most common courtroom dynamics in America. The judge is trying to determine whether the defendant understands the charges, not whether he agrees with them, not whether he's guilty, and not whether he has a defense. Yet many defendants immediately jump into explaining their side of the story. Notice how the judge repeatedly narrows the conversation back to a simple question. Do you understand what they're alleging? That's a crucial legal distinction. Understanding an accusation is not an admission of guilt. What's especially interesting here is that the defendant appears convinced that returning the package should end the matter entirely. Whether that argument ultimately has legal significance isn't something the court is deciding at this stage. The hearing's purpose is procedural, but because he's focused on proving he shouldn't be there, he keeps drifting away from the actual questions being asked. Viewers, have you ever noticed how some courtroom hearings feel like two completely different conversations happening at the same time? That's exactly what's developing here.
Okay, sir.
Explain
That's
that.
what the state alleges. Okay, sir.
Explain
That's
that.
what the state alleges for the habitual offender enhancement notice.
Do
You understand what they allege?
I understand that. I hear that, but
Okay.
I don't agree with it.
I understand, and nobody's gonna, in a few minutes, I'll enter a not guilty plea for you on it because you're innocent until proven guilty in this country. I need you to understand that the possible sentence related to the habitual offender enhancement is that you could have an extra 2 to 6 years if you're convicted of a level 6 felony, 2 to 6 years additional term, and it's a non-suspendable additional term. Okay? So if you're found to be a habitual offender, an additional fixed term between 2 to 6 years for level 6 felony can be imposed at the time of sentencing. Do you understand the possible penalty?
I do, and
Okay, that's all I need. And as required by statute, the court will enter a preliminary plea of not guilty for you on the habitual offender enhancement. Now, I'm transferring your case to
Okay.
DO6. Both of these cases get transferred to Judge Tody, and you have a hearing set with him on June the 15th at 8:30. So you'll be back in front of him on June the 15th at 8:30. And you should have copies of the order that I signed yesterday, or I'll sign today if I haven't signed it. That is the sentence for the contempt finding. I found you guilty of contempt last Friday, and I sentenced you to 6 months in the Porter County Jail. That's another reason why you'll be sitting in the Porter County Jail until the June 15th.
Well, then I can't go pro se like I got escorted out of your room because, I mean, I don't want to look like this in the courtroom. I want to presume, I got court
You said you want to proceed
I
pro
got court
se.
clothes at home that I was ready for court.
You said you want to proceed pro se.
Like this,
You want to proceed
I don't understand
pro
why
se.
you can't OR me and I be in court with my suit or tie.
And he will have to conduct a Feretta hearing related to the pro se. But in the meantime, I believe I have a duty to make sure you have an attorney within 20 days of being arrested.
I don't want an attorney,
And
sir.
I'm going to appoint the Porter County Public Defender Service
I don't
for you.
want that. I'm my own attorney. You know that, so does Judge Toady.
I don't
It's
think
so
you can get through
simple.
a Feretta
It
hearing,
is so
sir.
simple. I'm not a flight risk. You all know where I live at. I'm
Well,
sorry
you're
for
in jail
raising
now
my
because I
voice,
sent
but
you
I'm always put as a
6 months
different in this place.
for your contempt last Friday.
I
transferring the
don't
case.
call
We
that
have a
being.
hearing on June the
You said
15th.
something about
Go
chickens,
to
sir.
Judge Cody.
That is
and
not
we're adjourned.
professional. And
We're adjourned,
they
sir.
got that for me enough.